If you don't know, you don't know, then I'm sorry. I know that a lot of people are singing this song right now. Girl, you're obsessive. Cause I'm better than you. You guys got me hooked. You got me hooked on the comments. I had a really bad day yesterday. It was supposed to be such a good day. I won this case that I told myself if I don't win, I'm quitting. I'm quitting. Shitting and quitting. Not really shitting. Girls don't do that. But anyway, yes we do. I digress. So I was going to record this yesterday, but I did not have a good day. Because I swear every time that there is something good, someone just tries to ruin it. But we are not going to allow that. And instead, we are going to make sure that everybody knows that we are exercising our First Amendment right to discuss things that we want to talk about that are legally allowed. And that's what we're doing right now. So last night, though, I was laying in bed, and I was like, oh, let me go on my YouTube page. And I had a moment of conflict. I was a little bit discouraged about whether or not I should continue talking about this specific topic because of the backlash, because of, honestly, the shift in the fucking temperature of the room, and somebody just using my words and this entire scenario in the most, in my opinion, insane way possible. And regardless of their current status, they are like, fuck it. I'm gonna ruin your life, bitch. Let's do it one more time. So we're not gonna let that happen. And I've decided in the past, I think everybody knows the cycle. Cece loves to talk about it. There's a cycle, and part of my cycle was always that I would give in and I would fold. And that's because of my fear, and I've talked about this a lot. But in order to fully move on and move away from this, like I'm talking about in a couple of months, I want to never speak of this again. Unless it's in my book, which is coming. I have to talk about it, and I have to stand my ground, and I have to do what I know is right, and that is tell the truth. And that's what we're going to do. But it's not going to be like as messy as you think that today is. There's actually going to be part 2 today, and then part 3 in a few days. So part 3 might be a little messier. It might be a little bessier. I don't know. But today is not going to be that messy. Today's going to be more of like informational. It's going to be the breakdown of the federal court system. And then I'm going to kind of go through a particular someone's case with no sort of judgment or maybe some opinions, but just some commentary. And we're going to kind of dissect that after I kind of explain to you guys what my opinion of the federal court system looks like. I've given kind of like the shorter version of this on my TikTok before, but I want to kind of go a little bit deeper, Johnny go deeper. But anyway, for those of you that have been patiently and impatiently in my comments asking me for second part, here you go. And just be a little bit patient with me. As you cannot tell by my eyes and how swollen they are, it's been rough. It's rough being the center of someone else's universe. Anyway, also, I'm so sorry for the dance moves. That was embarrassing, but we gotta do what we gotta do. So, the federal system. So you might be asking yourself, what are your credentials? None. I'm a federal witness. I'm just kidding. I have some. So actually, when I started practicing law, my summer that I was an intern, the first case that I ever had was actually a federal case. The client was an individual who was a pharmacist who was charged and convicted at a jury trial of conspiracy to traffic oxycodone. Now, his defense at trial was that he was forced. They were scary drug dealers and scary addicts, and they came into his place of business and they demanded all the oxy they could find. And I believed every fucking word out of his mouth. I believed every syllable, every punctuation mark. And I fear that probably had a lot to do with why I ended up staying in this job, in this field, because I, as a result of that, trusted him, and I trusted his family, and I got to know his wife and his kids, and I felt so bad. I can say we lost this appeal, but he's out now. I have not had any contact with him, but I hope that he is doing well, because I really always hoped that he would. But after that case, I was really kind of hooked. I was like, damn, the feds are crazy. Because the reality is the feds are very, very different from the state. And so after that, my old law firm, the way that it worked is there was 3 attorneys for the most part of the 12 years that I worked, my 10 years I worked there. My managing partner did federal cases. So he would represent anybody from let's say I go out today and I decide I'm going to go commit a crime tomorrow. I could call him tonight and say, hey, pre-file, can you represent me from now until the end? He could say, sure. He would represent you through a plea if you want to cooperate, if you wanted to go to trial. And he was such a great trial lawyer. I say was just because I don't have any association with him professionally anymore. But he won so many cases that were so unwinnable, in my opinion. It was fascinating to me. And then he had this way when he would go to sentencings of humanizing the most disgusting, deplorable, diabolical humans on the planet, which is just so it was just like a very interesting thing to witness, if you will. So I got to experience that with him firsthand, and then I handled a lot of the federal appeals after that. And then I also dabbled my way into what is called a 2255. So in federal court, there is the United States Code. It's the statutes. And under 28 United States Code, section 2255, that is where you basically can argue that you want to file a motion to vacate your judgment and your sentence because your constitutional rights were violated, meaning you had ineffective fucking counsel. And I have won several of these, I can say. I'm very proud of that, to be honest, because they're not easy to win. My most memorable case, her name is Stephanie. She actually had a mandatory life sentence. She was charged. She was in a hotel room. The fact that I can still remember this years later is crazy. She was in a hotel room. Law enforcement came. She was charged with conspiracy to traffic methamphetamines. The problem was she had 2 prior felony convictions in state court for some sort of drug-related offense, which means she was looking at a mandatory life sentence at the time. And her lawyer said, oh, well, shit sucks for you. She was like caught red-handed. So the only way that she could have gotten out of this was to file a motion to suppress the evidence that they found in the hotel room. So they did that. Except he didn't call the main witness that could have fucking attested to exactly what they needed to prove. So my ass, years later, found this witness honestly on the side of the road. He was not doing well. And then there was a very big discrepancy, a conflict between the testimony of her lawyer and then my client. So I asked the judge, and she obliged. She got his freaking phone records to compare them to what he had said happened. And all I know is 6 months later, we won, and she was released. And that was honestly one of the biggest moments of my career. I think actually Kayla was visiting me when I found out, and I fell to the ground because I'm an emotional chump. I just am. Also, I know my hair looks crazy. Just ignore it. So, that is my background. That is my credentials. If you guys know who Tampa Tony is, I'm also responsible for getting him out of prison. I'm responsible for a lot of people out of prison in federal court. So I do have some sort of a background. And I think because of that, I am in a position that I can provide you with at least some basic knowledge of what this all looks like. So we're going to start in the very, very beginning of what's called an investigation. We all know what that means, okay? We all know what that means. And in federal world, that literally means the FBI, Federal Bureau of Investigation. Scary, scary, scary little agency right there. And I can say that firsthand after having some experience with them, only because they do their job well. And they do it very, very swiftly. No, not swiftly. Sorry, my bad. Quietly. They don't really give you a lot of updates. It can be very nerve-wracking. But they do it in a way that they are being as thorough and as rigorous as they possibly can, because they do not charge people that they can't convict. Truly, they don't. So if you ever win a federal case, it's because your ass is either amazing or you got lucky as shit. Okay, so keep that in mind. So an investigation, obviously, it can take years. It can take absolutely a number of years. And that's why federal cases are interesting, because you could think that you are scot-free out of the woods in another world. And then one day, knock, knock, knock. The feds are at your fucking door, seizing your electronics, and you are like, oh, that's interesting. I've had cases, this is just can kind of explain to you how long this can take. I had a client, his name is Michael. God bless his soul. Just like a sweet man. Truly just did not understand what he had done wrong. He was a catfish, though, which is interesting to say the least for me. But he actually spoke to law enforcement multiple times over the course of 2 years, and he thought that he was fine because he willingly handed over everything that he had. He's like, you want my phone? You want my laptop? You want my hard drive? He handed them everything that he had, and then he went and picked it up 6 months later, and they acted like everything was fine, and then a year and a half after that, clink, clink, boy, you're going to prison for a long fucking time. And he was very confused. He's like, well, I don't understand. I cooperated. I obliged. I did everything. I didn't ask for my lawyer. And I go, I know, and you gave them their entire case. You gave them the whole case. It just took them 1.5 years to corroborate and confirm everything that you had told them. So he's in prison still. And I unfortunately could not get him out because a lack of awareness or a lack of education is just not a defense. It's just not a good defense that you can ever really use. What he should have done is what everyone else kind of already is aware of it happening in the case that we're going to talk about later, is you can do what's called like a pre-file. If you think that you're being investigated by the feds, you can go and contact a lawyer and you can basically talk to them about what your options are. And once the attorney is able to confirm with some sort of agent or an assistant United States attorney that there isn't an ongoing investigation, they can find out, number one, where the investigation is going. Number two, how far into the investigation it has gone. Number three, if there's any way, shape, or form they'd be willing to pause or cease the investigation if there were to become an agreement had between the parties, right? And the reason behind this is a couple of things. People were very, very angry with me when I tried to explain this originally because I mentioned this before. My biggest regret is providing a list of names and some introductions between a party and some lawyers. And I don't know. I guess at the time number one, I didn't think that I would actually be successful in matching the two. I'm not a matchmaker. Nope. Never been me. I got lucky with this guy, but she got matched. She got matched. And unfortunately, it was not one of the 5 that were shittier that I gave her. So no big deal. However, what happens though, once you're matched with a lawyer, the goal of that is to try to resolve things in the best way that's possible for everyone but the defendant, okay? And let me just give you an example. Let's just use like a famous person, Anna Delvey, inventing Anna. Do you guys know anyone that's similar to that? I'm not quite sure. I think that there are some people that are worse. I don't know. But anyway, for her, what I think could have happened if she would have found out, she could, you go and you talk to law enforcement, you talk to the FBI, you come to an agreement. They're like, we've only investigated about 2 years worth of what we believe is a 10-year investigative range. A range that you defrauded others for over 10 years. In that moment, as an attorney, the goal is to get the most for your client and also the most for the victims, because that is what they're looking for. The government's like, I don't give a shit about your client. I want to know, how can you help me? And then maybe I'll help you. And that's why federal proceedings are very, very interesting. And they're very, very uncertain because you will never know, ever, how it will play out. Even if you think you do, you have no fucking clue. Because it's not up to you. It's not up to the government. It's up to the judge after all that's already taken place. And I'll get to that in just a minute. But so anyway, so if you are an attorney and you are just trying to get your client the best set of circumstances, it might behoove you to have a conversation and try to come up with an agreement. Especially if they know they've done it. Especially if they are contacting you. It normally means that they are aware that they are under investigation and they have fucked up. We've had plenty of clients that come in so scared and they're like, okay, I've done X for this many people. I'm so concerned. Help me. Okay. That's a little bit scary, but yeah, let's do it. And what comes of that is that it's a win-win for both parties. It's a win for the government because they don't have to keep researching and doing this investigation further back in time. It is a win for the victims because there's a higher likelihood of them receiving restitution if this is caught early. It is beneficial to the defendant because their ass is not going to be held accountable for as many charges as likely as they could have officially. Okay? Officially. So obviously the goal, I had to kick the fucking dogs out because I could not stop hearing them just in my fucking ear. I'm going to shoot something and it can't be them because I'm not a violent person, okay? I'm just not, even when I'm angry. Anyway, so the goal obviously for the government is to get as much direct evidence as they possibly can because nobody wants a case on circumstantial evidence if they don't have to. They want to be able to sink that basketball in the hoop with 0 questions, no concerns. It's going in. Swish, bada boom, bada bang, 3-pointer, no big deal, win the game. So the way that they do that, though, is they will do a lot of records requests. They will talk to witnesses. They will get subpoenas from businesses. And they will just compile and compile and compile as much data as they can until they can prove the fuck that you did something really bad. And that sucks. A lot of times you will be on notice because you will get an alert that you are under investigation, and that just kind of also sucks for you. But that's when you should actually speak to somebody in a professional capacity if you've done something wrong. That's just my 2 cents. Legal, non-legal advice, if you will. So once they have they've finished their investigation, and when I say finish, I mean they have done enough of their investigation that they can either come to the agreement with you. And if you do enter that kind of a pre-filing agreement, normally it is in exchange for them agreeing not to look further. So I can only use the case that we've been talking about for an example. It was understood and agreed upon that when they came to their agreement, they would not search for they would cease investigations and they would stop looking for other crimes to hold her accountable for. That is very simple. That is very, very normal. That is very on par. Because what I was mentioning earlier is you can be charged officially with certain crimes, but you can also be still held accountable or liable for unofficially charged or similar conduct, if you will, because you can be given points for crimes that you're not charged with when it comes time for your sentencing that you might not even know exist unless you have a really good lawyer. And the reason I know this is because oftentimes I am arguing ineffective counsel because a plea was entered involuntarily or unknowingly because they did not have enough information to make that decision. I will go back to this Michael character. He was charged with possession, distribution of things, okay? We all know. And for him, he was only charged with, I think, 6 counts, but they were able to stack up every image that existed on every hard drive, every electronic all the things. And it enhanced his sentence at least 10 years. And he was like, what are you talking about? My lawyer never told me this because oftentimes it will not be found in your plea agreement. We're going to come back to this, okay? So just hold that thought. So we're going to go back, though, to the end of the investigation. You're either going to go pre-file, which that's what we're talking about now, or you're going to go grand jury route. So in order to be convicted in federal court, in order to be charged, you have to have your case heard by either a grand jury or you got to waive that shit. So I low-key would love to be on a grand jury. That is, I do think, what a TV show would look like because, I mean, I'm only speculating because this is one thing I don't have any background or information about. I have no education. I have no degree qualifications or anything. I'm just assuming that it would be kind of cool because what I understand is you don't get a lawyer. The government is allowed to put on whatever evidence they want, whether it's admissible or not. And there's nobody there to like object or ask questions on the other side. So it's a free-for-all, okay? It's why a lot of people will waive that if they get the opportunity. But most people don't know they're under investigation, so they don't waive that. So you have to be charged via grand jury or you have to waive that. But there is another option that you can also come into contact with, but there's another option. You can be charged via criminal complaint at first, and then within 30 days, the government has to bring your case before a grand jury. Now, why would they do that, right? I have seen cases where they will file a criminal complaint in 2 different sets of circumstances. Number 1, it is a case that is time sensitive. They have evidence that could be lost. They have someone that they need to make sure does not flee the country, etc. And then they have 30 days, unless they get it extended, to take it before a grand jury. You know the drill. The other set of circumstances is the people that they don't really have a lot of evidence on. And they are afraid that if they do not charge them now, they'll never even get that opportunity. And maybe if they charge them, they will be able to get some information from them. I have we're going to call him Joe, okay? We're going to call him Joe. I know someone named Joe. He's not in custody right now. He's not a client of mine. I just know him from another life of mine. He was charged via criminal complaint. He did not waive his indictment because that would be fucking dumb. And he is currently coming up on the tail end of the deadline that the government has to go before a grand jury. And I'm willing to bet my ass, both cheeks, that he is not going to be indicted. And I actually like this for him. I'm not a huge fan of this person, but I am incredibly happy for his family because the charge that they were alleging against him was not the greatest, and it really damaged his reputation where he's from. And when I heard it, I was like, no chance. There's no way. I'm like, he's a weirdo, but not that weird. Anyway, I digress. So he was not willing to waive his grand jury, and so we will know shortly in the future whether or not he's going to actually be charged or not. And if he ain't charged, I hope he sues the shit out of all those people that defamed him and put his name in the papers and just made him look like such a crazy person. But so those are your options. There's really not many. If they don't have a case, they're not going to take it to a grand jury. And if they don't take it to a grand jury, they ain't got you. But if you go to a grand jury, you're doing the perp walk. They are coming handcuffs and all. They are not coming as one police officer. They're coming FBI. They're coming with U.S. Marshals. They are coming with everyone. And they are going to come, and you better go nicely and quietly or else your ass is grass. And I can say that because Brandon's sister is a U.S. Marshal, so she's a badass and she scares the shit out of me, but I love her, so I am on her good side, so don't fuck with me or you will fuck with her. And I promise you, family means a lot to this group right here. So I digress. Just a little bit of a note on the grand jury aspect of things. The burden of proof is different. So when you go to a jury trial, we all know, you are innocent until proven guilty, beyond a reasonable doubt, in the United States of America. We're all innocent, okay? Until you either plead guilty or you're found guilty. A grand jury is not the same. It is not the same. A grand jury is actually probable cause, which is a relatively lower burden of proof, if you will. And the reason that they do that, again, is because they want to be able to continue to build the case, but they have enough information that they want to make sure that your ass is charged. Okay? So, yeah, you've got your complaint, you've got your waiver of a complaint or an indictment, that's an information, and then you've got your grand jury indictment. So, the last option that we know about from this other person, the waiver of an indictment. It's a very interesting concept, in my opinion, because a couple of things become true. Number one, a grand jury never has to see your case. There's no lower burden. There is also no perp walk. You are basically waiving you're waiving the government's desire, or you're jumping over that, like the in custody part. Because what normally happens is you get arrested, you go into custody, and then you either get to bond yourself out, or you're ROR'd, released on your own recognizance, ankle monitor, house arrest, what's up, or your ass is in jail until you go to trial or you take a plea. And if you are in this area, that Pinellas County jail is stinky. I got arrested in law school. I know. Who would have ever thunk? Whoever would have ever thought I would do that twice, I'm not quite sure. Definitely not me, and will never do it again. So I really do feel for anybody that has to go through that, because that shit stinks and the food is nasty. But you can see your lawyers if they do care enough to come visit you. Yeah, it's just not a good, it's not a good situation. But anyway, I do hope that everybody that deserves to get some sort of a bond gets a bond. But you have to prove where you got the money from, right? So let's just say you get taken into custody and you want to bond out, you want to bail out. You have to have money, and you have to prove that it's not obtained through criminal acts, which is interesting. It's very interesting. And I've seen it go all the ways, both ways, good way, wrong way, back, forth, up and down, you name it. And I've seen it, and they're very strict about that. They're very strict, as they should be, because why would they ever allow you to use fraudulently obtained funds to then get out of jail and then likely or possibly flee? Sounds like a pretty interesting escape plan to me. It really does. So let's get past the whole jail thing, because if you're in jail, I do feel for you, because the next part of this is going to be very difficult. You're going to go through the discovery phase. That just basically means you are giving the opportunity to discover all the evidence they have against you before they slam the door in your face. I'm not trying to be funny, but I kind of am, because if you don't laugh, you will cry, okay? So discovery is a little bit different than state court. A lot of the times the evidence that they have is very sensitive. They don't have an obligation to give you a witness list. So I am a witness in a federal case, but I'm not on any witness list. That case also is not going to trial more than likely, so I'm not going to be needed as a witness, so it's okay. A lot of the times if it's sensitive material, they will come to an agreement on the record, a very, very strict order of compliance in terms of you may show your client or tell your client what these CDs show, but you are under no right, obligation, you are not allowed to give them access to this, because it's a fucking crime. Normally it's illegal images, and you're not allowed to have access to that, okay? During this process, though, is also when it's very important that you talk to your lawyers and you tell them if you're innocent or not. And if there's people out there that can prove that, you tell your lawyer. You tell them immediately. You don't tell the police. You don't tell the feds. You don't tell the U.S. Marshals. You don't tell the agents or the courts or the prosecutors. You tell your lawyer, if you're innocent, you say, these are the people, phone numbers, addresses, family members, dead relatives. I don't care. You say, get on it. Get on it, Janet. Let's find them. Let's get this thing going, because if you are innocent, you better get ready to fight for your life. Because like I said, it's not the norm that you would be innocent and be charged in federal court. So just keep that in mind. So the discovery process is where you have the opportunity to tell your lawyer how you want to help. You have the opportunity to build a strategy, and you have to decide right then and there whether you want to take a plea or go to trial. As you become more aware of the evidence, it should become relatively clear what you should do. Your lawyer, though, has an obligation to explain all this to you. They have an obligation to go over all the evidence. They have an obligation to go over what the elements of the crime that you're charged with are. So, for example, if you go to a trial, the jury has to hear evidence, and the government has to prove beyond a reasonable doubt several elements depending on the crime. So, for example, if it's conspiracy, there's going to be elements that they have to prove, such as an agreement to commit a crime, and then acts that were taken in support of said crime, etc. And they have to prove each of those elements beyond a reasonable doubt. So, if you are not provided with a full overview or full access to your evidence, if you are not told exactly what the government plans to introduce or prove, if you are not told what elements they have to prove, arguably from a post-conviction standpoint, you, my friend, are not taking a plea voluntarily or knowingly because you don't have all the information that you would need. You don't know all the consequences because you don't know all of the evidence. So if you don't have A, you can't have C without B. A plus B equals C, you can't have that, okay? So that becomes a problem that you would then bring to me, and then I would try to help you overturn that. But that's not what we're talking about today. We're not talking about post-conviction because we don't have time for that, okay? So depending on what you think, if you are feeling it, you're feeling real ballsy, you're thinking, I am confident, I'm innocent, you're going to say, fine, let's take it to trial. There's a couple of things you need to know, though, about a jury trial in the feds. You will get dinged if you get found guilty. In state court, you cannot and will not be given a harsher sentence. It is unconstitutional if you're given more time just because you went to trial. That is your constitutional right. You're allowed to exercise it. Federal court, they say fuck off. They say you're wasting our taxpayers' dollars and our time. If you choose not to accept responsibility and you actually don't even think about testifying, if you go to trial and you lose, you already get one ding. If you go to trial, you testify and you lose, that is literally like, oh, you are in some deep shit. You're in some deep waters because they look at that as perjury. It might not be perjury. It might not even be false evidence. It might not be you're as nervous as shit. You have a bad background. You gave really bad statements. A jury has every right to just chuck that out the window and find you guilty. And if and when they do, the judge will absolutely say that you are deserving of more time. I know it does not seem fair. That's why you have to weigh all of your options, and that's why you have to know about all of your options before you go through this. So if you take a plea, it's normally an agreement, right? So it's normally just an agreement where there is an understood expectation. Because like I said, there is no promise. There is nothing that is certain. The only thing that is certain in this life is death and taxes and apparently prison for some. Not for me, but for others that we'll get into later. So what ends up happening, though, is you enter into an agreement, and there is a range because there is what's called a guidelines, okay? In federal court, you are given a guideline sentence range. And that is calculated based off of several factors. Number one, the offense in which you are being charged with. Number two, your criminal history. Number two, did you accept responsibility? Number three, did you go to trial or did you commit perjury possibly? Obstruction of justice. Four or five? We're going to say five, but I feel like that's only four. But anyway, five. What is five? Did you cooperate? Did you do substantial assistance? There's a whole plethora. And then number six, this is not like an official one where it's going to determine or dictate your guideline range, but if you have a lot of mitigating circumstances, those will all weigh in your favor, right? So if you have a long-standing history of mental health issues, I don't even know. Don't even get me started on that because that's a whole nother video from a whole nother lifetime from now. So those are kind of like the things to take into consideration. And it does vary from case to case based off of the number of individuals involved, restitution amounts, etc. So once you have that range, the government is going to create an agreement with you. Now in state court, when you get an agreement, you are agreeing to a certain number. You're agreeing to 5 years, followed by 5 years of probation. In federal court, you're agreeing to a range, and the government is agreeing to recommend a sentence at the low ends of the guidelines. So let's say you're facing anywhere from 48 to 62 months. If the government puts in the agreement that they will recommend a sentence at the bottom of the guidelines, that means they will recommend that you receive 48 months. Now, class, does that mean that he has to, and by he I mean the judge, does that mean the judge has to accept that? Absolutely not. The judge could say, I hear your 48 months, and I'm going to raise you up to 62 because I find that you committed crimes, you don't care about your victims, you have not accepted your responsibility, and you are wasting the court's time. Have fun in prison. You may appeal this ruling if your sentence is illegal. Boom. There's never a guarantee. If you think that you are not going to go to prison because of a guarantee, then you are so sadly mistaken, and I fear you'll need my services, and some of you won't be able to have them. That's just the facts. So ask your lawyer every question that you can even think of asking. Write it down. Put it on the record. If you've got concerns, if you've got questions for the judge, fucking speak out. I know that sounds crazy because why would you? But you should. Because if you don't, you will regret it. I pinky promise that you will absolutely regret that. Now, before I go into more about that, I do want to touch on one other thing. There's a very big difference between state and federal courts because normally in state court, you are arrested relatively quickly. And then they do their investigation after the fact. So, like, for example, state court crimes are normally things that are happening in a moment's notice, right? So, a robbery, burglary, schmurder, those kind of things, right? So, they're going to be, if they can find a suspect immediately, they're going to be arresting them, and then they will conduct the investigation thereafter, okay? Versus a federal case where they are doing the investigation long before they ever arrest anybody because they are normally crimes that require significant amounts of proof to kind of tie in all the links. There's a lot of conspiracy charges. It's a lot of agreements, to be honest, because that is the easiest way that they can actually get somebody without concrete direct evidence, because those kinds of cases are based entirely on circumstantial. If you don't know the difference between those, I was trying to think of like a really good and an easy example. Direct evidence would be literally if somebody caught me red-handed, or if I had a friend that told me to my face I committed this crime. That is direct evidence of their guilt. Circumstantial evidence would be like, I saw her with the black purse that was found at the crime scene or something like that. It's a bunch of pieces of evidence that you can put together and you can infer the guilt because of that. So it's not as straightforward, it's not as easy to judge, and it is definitely a trickier case. But when it comes to like conspiracies and agreements, it definitely gives the government a little bit more of like a leeway because it's not as strict in terms of like what you actually need. It's definitely a more lenient scale in terms of the depths of the evidence, if that makes any sense. Okay, I just was watching the first part back because I needed to know exactly where we left off because it's been a couple of days and I was like, oh my god, my hair looks so dark, because it is so dark. I feel like you guys are seeing it here first. But anyway, welcome back. As you all know, my life has been extremely chaotic and I'm very unwell. And I feel like everybody knows this, but I had to hire a lawyer, and the amount of money I've spent on this case just continues to rise. So I've had to spend the last 2 days really like focusing on that so they can represent me in the best way that I need to. They're not representing me like in a criminal side of things. They're representing me as the victim. So that's also a new kind of dynamic for me that I'm not used to. So I do apologize, but here the fuck we go. We only have a little bit left to touch on before we get into the motherfucking meat and potatoes. And I know that's why you guys are here. So while this prints out, because I am printing out some things, some legal documents, there's only really one other topic that I want to go over, and that's called a cooperating witness, okay? There's been some discussions and some of the comments on the talk from some individuals associated with this person that we might be doing a case study on. Some people keep saying, what's a cooperating witness? First of all, I have a whole video on this, okay? I have a whole video about this on a state case of mine, number one. Number two, there's nobody in that case that could cooperate. So, like, they're just totally blowing smoke up your ass. If you want to believe that, that's fine. But if you do, then you like anal. My bad. I should probably delete that. But also, I'm not going to because it's fine. We are unwell. We've been unwell. So, a cooperating witness is somebody that basically just rats. You're going to rat on your friends. You're going to snitch on your sister. You're going to flip on your family. But in return, you're going to get a couple years off your sentence. So if that's up to you, if that's kudos to you, if that's good with you, then that's good with me. I don't care. I've never been somebody that's like telling a client that they have to cooperate. I have seen lawyers like that, and I think it's kind of risky, and it's very, I don't know, it's unfortunate. Obviously, if somebody knows something, I am a snitch, guys. I am a snitch. I am. I gave lip on. Never mind. I'm done. But anyway, so if you do cooperate, though, you will get less time. There's a thing called substantial assistance. It's either going to happen before you take your plea, or it's going to happen after if you learn information in prison. And whether or not that information is helpful is a very, very big part of whether or not you will get the time, the credit for it, because the government is only going to suggest that you or recommend that you get a lower sentence if you help them out. You scratch their back, they'll scratch like maybe your one toe. So if you cooperate, let's say you cooperate beforehand, you get that bag, sis, you get a lower sentence, cool. If you cooperate once you're in prison, it's called a Rule 35. That's just the rule under the federal rules, a procedure that allows an inmate or a defendant to file a motion with the court. But it's not the inmate. It's actually the government that files this. And then it's normally on the defense or the defendant to follow up with the court. But anyway, they'll go back to court and they'll get a lower sentence because of this, if they've done a good job. And it's really interesting because everybody in these situations, you would think is the most incredible human. Like, they have access to information. They're also in prison or in jail. But I have seen more juries convict somebody because of arguably false testimony than anything else. So don't ever underestimate the power of the potential lower sentence. Oh, I was going to say something else, but I don't know. But that's pretty much all I have, guys. That's it. That's all I have on this. And now I want to take you guys into your first class of law school. I'm going to raise my desk because I cannot keep sitting. I'm going to fall asleep. I'm sitting here and my eyes are dragging. I hope you're ready because we are officially getting into the case study today for the class. I'm only going to say the case name one time, and then after that we're going to call it the defendant. Does somebody in the audience want to tell me a little bit about the case of United States of America versus Elizabeth Teckenbrock, a.k.a. also known as Elizabeth Nicole Weekly? That is Weakly for the record. That is case number 826-CR, which stands for criminal. 230/TP/Todd Pam Bondi absolute ass Middle District of Florida, Tampa Division. The defendant's name is Elizabeth Teckenbrock. We will refer to the defendant as the defendant from here on out. The United States of America is represented by Gregory W. Kehoe, who is the United States Attorney for the Middle District of Florida. The defendant's lawyer is an individual named Mark Rankin. And pursuant to a plea agreement, they've come to a very interesting agreement. However, before getting into that, I think it's important to kind of go through the charges, which they do that in this agreement. And so we're not going through this whole thing, guys. It's 19 pages, okay? But what's interesting about this, though, is we all know from other information that this is a pre-file information, right? Pre-file agreement. And what did I tell you guys? Who wants to raise their hand? Oh, you look really interested. What? Oh, she agreed that they would stop looking into the other crimes that she committed, and in exchange, she would only plead guilty to the ones that they already had, right? Is that what you meant? Great job. I wish I had like a cookie I'd throw it at you, but you're not a dog, so yeah, that's exactly what this is all about. So essentially what has happened here is there is a very wide range of time. It is from 2021 until December of 2025 that the FBI looked into and investigated, because we investigate in federal court before we charge. They investigated whether or not there was any crimes that had been committed that they could prove. And again, proving the crime is the key. It doesn't matter what you think. It doesn't matter what I think. It doesn't matter what Andrew thinks. It doesn't matter what anyone thinks. It matters what the government can put on a fucking whiteboard and show a jury that doesn't know anything about this. However, we really don't have to get into that because we know that this is not really about that. This is just a very not a quick scheme, but this was a quicker resolution than it would have been if they would have continued on with the investigation. Actually, you know what? I don't care.
I'm going to send you whatever the fuck I want.
I don't care if this person's name is in it because it's only his first name. I really don't care.
I'm decided. Because I'm actually pissed off now. First I was hurt, now I'm pissed. You have the audacity to sit here and say that I did not hear your feelings. You don't matter. Fuck you. Honestly, I hope you listen to this over and over again. How dare you gaslight me, you manipulative piece of shit. You are the definition of a narcissist. You think that you don't matter because I sometimes tell you that I don't want to talk to you during the day or at night because I'm fucking busy with my big girl life? How about you? have never made me feel wanted or important. You've never shown up for me in person in 11 months.
Y'all, I literally though want to get that made on a shirt or a hat or a coffee mug. I even made a design on Canva. Like, I've never been into merch. I think that's, like, lame. Sorry to everyone that does that. Like, I'm like, ew. I'd rather people spend their money on, like, something that's important, like a charity or, like... I really, after my client got out of prison this week, I really am interested in starting, like, some sort of a charity or, like, an organization that helps people directly when they're getting out of prison. Like... volunteers that will start writing to this person. They will communicate with them. They'll get to know them, and then they'll pick them up if they don't have family. So anyway, I digress. But my busy with my big girl life was like the funniest shit I've ever said in my life, and I can never do better. Okay, so we're about to go through the plea agreement because it's really the only document that you need to go through, because on the docket, which is the clerk's website, it's basically just the area where you can find every single document that has been filed. That's why it's called the document. I think I just made that up, actually. But in federal court, there's a thing at the very, very top. Here, I'll show you. Not you. It says document, and then it says a number, because at the beginning of every single document on the docket, there is a document number. Holy tongue-tied mother truckers. But they do that because whenever you're referring to a document in court, you're supposed to be able to refer to the citation so the judge and the other parties can actually look at it and pull it up. So this would be document number 4, and I already said the case number. So the defendant in this case has already entered into an agreement. I've already gone through, like, the whole, like, waiving of the indictment, waiving and accepting an information. That's very, very, very rare, in my opinion. I've actually never seen a case like this in my entire life. I recently had to hire my own lawyers again, not as a defendant, but as a victim and as a witness, to try to establish the rights that I have been entitled to this whole time, and to not have to deal with the stalking and the harassment and the actual just the constant feeling of having a heart attack every day of my life. That's probably why I'm also talking very fast. And when I told them about this whole situation, it's my friend from law school and her dad. And they're some of the best lawyers that I've ever met. So it's my friend Liz. I know, the irony's not lost. But she ran for state attorney. Her mom's also an amazing investigator. And her dad's an amazing criminal defense attorney. And her dad was like, this is crazy. I've never really seen something like this where they took a plea before they ever even went to their first appearance. So that was a really interesting, that was a really fun lunch where I got to tell her dad all the things that I have had happen to me, because she did not know. She just did not know about the Bahamas. He didn't know about the Bahamas, etc. She's the good Liz. So it's kind of like, no, we're not even going to say that. I'm just going to make it a comparison, but we're not. I was going to say wicked, but we're just not going to do that. We're not. It's just good. And then there's just the other. There's the good Liz and the defendant. So this defendant actually waived her right to have an indictment before a grand jury, and the reason behind that is just pretty simple, is that my understanding is that she did not want to actually go into custody, and she waived that option to get that option. She waived the right to go and have a grand jury decide her fate, and in exchange, she will not go into custody in the meantime. Normally, if you do go into custody, though, you'll have a bond, you'll have to pay it, or you could be released on your own recognizance. One of the interesting findings, I will say, and I didn't think about this until just now, is that one of her mentioned victims actually paid her bond on her state case once. I was not aware at the time. Ironically, and I say that I wasn't aware because I actually was the person who called my bondsman. If you saw part 1, you already know this, but I find it incredibly ironic, and I do hope that gets brought up in court, because I think that it's just so significant to this whole thing and this whole situation. It just shows you how deep this actually goes and how icky it is. We love RP, though. No doubt there. So this defendant, she agreed to waive her indictment. However, she's been charged by information, which basically lays out the charges. So she's been charged with 2 counts. Count 1 and count 2 both charge the defendant with a violation of 18 U.S.C. 1343. What that means is Title 18, United States Code, and then the statute section is 1343. So in the plea agreement, normally on the docket, it would give you like a bunch of documents. It would normally be like indictment, first appearance notes from the first hearing. It would be like terms of pretrial release, discovery notice, notice of appearance, notice of government appearance, notice of U.S. attorney, like all these things. There's only 5 documents on her docket. And they are literally information, waiver of the indictment, I want to say notice of appearance, maybe the plea agreement, and then a notice of hearing for her plea. But that's pretty much it. It's the most straightforward thing that I've ever seen in a case like this, but we're moving on. And we're not going through all this because it's just too long, but the maximum penalties is the next section of the plea agreement. And so when somebody takes a plea, they have to sign every page. They are basically agreeing under oath that they have gone over this with their attorney in full. I have seen many lawyers do this. All right, Joe. This page right here is going to say elements of the offense. Can you read? No, you can't read. Let me read it for you. Number 1, you did something shitty. You devised or you participated in a scheme. You defrauded people. You said you had cancer. No big deal. Number 2, they can do that. Number 2, false pretenses. Can you read that word? Can you read? Okay. The representations that were false were about material facts. You don't have cancer, right? Okay. That's material, and that was false. Number 3, the defendant acted with the intent to defraud. We know you did that. You don't even ask me about that. And then 4th, etc. So in a normal, and I've seen that happen a lot because a lot of times when a defendant enters a plea, they sign this document and they don't have time to go through it. And if they don't go through it with enough time and then they go to court and they have to swear under oath that that's their initials and they read the whole thing or they read the whole thing, that's called perjury. And in federal court, you really cannot go back. So like what you do on that day, you are stuck with. A lot of times I argue in ineffective counsel motions that an attorney told their client what I just said, and they told them to just say yes in court. And I have had a case once where the judge asked me to come to court with my client, and all he did was bitch him out. He said, "Sir, are you admitting that you perjured yourself because your attorney told you to say that, and you really just wanted to get this plea done, but you didn't mean what you said?" And he goes, "Yeah." And he charged him with perjury right there. It was a learning experience. He also doesn't understand how he's a catfish, which I talk about him in the earlier part of this video, so you guys will get to see that later, and you'll enjoy it, I think. He's actually a nice guy, but he doesn't act the age that he is, if that makes sense. So, the plea agreement goes through the elements of the offense. The elements of the offense are actually this. So each of her counts are the same. So in order for her to plead guilty, she's understanding that she's acknowledging that the government can prove these beyond and to the exclusion of every reasonable doubt. And the elements are this. Number 1, the defendant knowingly devised or participated in a scheme to defraud someone by using false or fraudulent pretenses, representations, or promises. So my professional take on this is that I can already tell based off of this. So she did a couple of things. Number 1, she misrepresented that she had cancer when she did not. She misrepresented a lot of things. I think she said she only had 2 children. That's not part of this, but there's just obviously a lot more facts to this case than we all know. Because the second part of the charge is the false pretenses, representations, or promises were about a material fact. So it does not matter if the defendant told a million lies. She could have said that I am a lawyer, I don't know, and that would not be material to this specific crime. It could be relevant in other areas, but it's not to the actual elements of the offense. Number 3, the defendant acted with the intent to defraud. Obviously, the intentions of telling someone you have cancer and asking for money for your treatment is to get the money and then use it on yourself. Number 4, the defendant transmitted or caused to be transmitted by wire some communication and interstate commerce to help carry out the scheme to defraud. The end. Okay? Those are the elements. This is the part of the agreement that says no further charges. And I will also say, if you guys want, like, I think that Chelsea CC read through the whole thing on hers. I'm not going to do that. Like, that gives me, like, I'm crying of boredom. I can see the tears down my cheeks. I'm not doing that. I've read too many of these to deal with that. I'm only going to go through the really important parts, but the no further charges is really interesting because it literally says, if the court accepts, because the court does not have to accept. If the court accepts, the U.S. Attorney's Office is not going to charge the defendant with committing any other federal criminal offenses known, not unknown, known to the United States Attorney's Office at the time of the execution of this agreement, related to the conduct giving rise to this plea agreement. So that's really interesting. Let's break this down. Let me get a highlighter. Hold on. I'm kind of lost. Okay. So a couple things. I don't know if you guys are as analytic as I am, but I'm forced through my job to really recognize words. So obviously, if the court accepts is a very big conditional phrase. No big deal. This is for my class of law students in front of me. The United States Attorney's Office agrees not to charge defendant with committing any other federal criminal offenses known to the U.S. of A. So that means if there's an unknown crime that goes unreported or uninvestigated, someone should probably let someone know that they could still be charged, okay? And again, at the time of the execution of this agreement, again, this is actually kind of a loose statement. Arguably, the execution is when this agreement is signed. However, there could be a legal argument, I don't know if it would be successful, that this actually was not executed until she went under oath and a judge agreed to it. But I digress. The last statement that I think is interesting is related to the conduct giving rise to this plea agreement. So that means there could be a situation where there's other conduct. Like, for example, I think that would mean that any conduct related to the misinformation about cancer. But what if somebody gave different information? What if somebody catfished somebody else and defrauded them that way? Or what if they had been providing misinformation about being a survivor of domestic violence and they actually were not? Or they had done anything. I mean, they could have committed perjury. There's a million other things that could happen. But I just think that that's a really interesting statement. And I think it's important that individuals who sign these know that there's a lot of ifs. There's a lot of like gray terms in here that are not really defined in a manner that would be beneficial to them if they commit crimes. So we're going to keep on going because there's only like a couple more sections before the actual facts. The number one thing that I think people want to know about, or at least I do, is I always look for the acceptance of responsibility, because that basically means you're not going to trial. If you go to trial in federal court, they will raise your sentence. They look at that as like a miscarriage of justice and a waste of their time. And so you get 3 levels off of your sentence if you accept responsibility. And that's also why attorneys will often tell their clients, or they will lie later and say they did not do this. But they will often tell their clients that if you go into this courtroom right now and you don't agree with what the judge is saying, you will not get those 3 points reduced. Those 3 points can give you a couple of years off of your sentence. So a lot of times individuals will go into court, they will take the oath, and then they will blatantly lie and say they've read every line. But I'm going to be honest with you, I don't think some of my clients can pronounce these words. Anyway. So that's a really interesting thought, but anyway, it doesn't matter. So within that same paragraph, though, it says, at the time of sentencing. Oh, Lordy, I forgot about this one. Oh, Jesus, take the wheel. Oh, there's 2 points of this I want to bring up. Okay, number 1. The defendant understands that this recommendation or request is not binding on the court. And what does that mean? What does that mean? Who wants to take a guess? Anyone? Anyone? Is that Jacqueline? My girl. My girl. Anyway, so that's so funny. I love it. The court can change its mind. So the court can actually take their agreement. They can accept it. However, that does not mean that they have to actually impose the sentence that the government recommends. So let me give you an example. Let's say that I take a plea and I think that based off of my guidelines, I'm going to get a sentence of anywhere between 24 months and 36 months. Based on my agreement, I have been told by my lawyer and by the government that they're going to recommend a sentence at the bottom of the guidelines, which would be 24 months. For some reason, though, the government finds out between when I took this plea and when I go to sentencing that I have been fucking around. I have been, let's say my crime is for conspiracy to do something, I don't even know. Let's just say that I have passed off my responsibilities onto a friend, but I'm still communicating with them. Let's just say we commit a crime. 2 things can happen. You go to court at the time of your sentencing and the government says, no recommendation for you. Goodbye. That's number 1. The second thing that can happen is the judge can outright tell you, I'm not accepting that recommendation. I've heard from all these other victims. I have received all of these letters, even though they're not named in the indictment. They're not named in your pre-sentence investigation. You are a piece of shit. You've hurt a lot of people, and I don't think that your agreement reflects that. If they want to go above the end of the guidelines, so I just made the example of the 24 to 36 months. They can go above 36 months. For my crime, let's say it's the same as the defendant's, up to 20 years. They could give you up to 20 years, but they have to give you a reason. They have to give a legitimate reason that is based off of the evidence that is presented at the sentencing, that you are not somebody that should get a sentence within the guidelines, but you are somebody that should absolutely serve more time. This is where plea agreements in federal court get really kind of like dangerous, because state court, that would not happen. You would be allowed to either withdraw your plea or the judges wouldn't accept it. These are 2 separate dates entirely, and you're not guaranteed a single thing. So just something to be aware of. You know, Oh my god, poor Jackie. She's about to like expose herself hardcore here. Everyone be nice, okay? We love her. She's my little empath, so be kind. The other thing that's interesting about this one, and then after this paragraph, I'm going to go on to the facts. At the time of the sentencing, if the defendant's offense level prior to operation of subsection A is level 16 or greater, wait a second. Sorry, I gotta look at that later. That might be in part 3. And if the defendant complies with the provisions of United States Sentencing Guidelines, sections 3E 1.1b, and all terms of the agreement, including but not limited to the timely submission of the financial affidavit referenced in paragraph B.5, the United States agrees to file a motion pursuant to United States Sentencing Guidelines, section 3E 1.1 for a downward departure of 1 additional level. The defendant understands that the determination as to whether the defendant has qualified for a downward adjustment of a 3rd level for acceptance of responsibility rests solely with the United States, and the defendant agrees that they cannot and will not challenge that determination, whether on appeal or otherwise. So what that means is this. My understanding, and there is a forfeiture of the assets paragraph, and I'm not even going to go into it because I've already read this, is the defendant, I almost said the suspect, the defendant has agreed to pay back money because she owes a lot of money, and she has no money. She has apparently alleged that somebody that she knows is holding on to it for her, and she's willing to take a lie detector test. It's not admissible in court, but it is used in these circumstances because every proceeding is different. So I am very interested. I have, as an aside, and this is not me acting in my professional discussion of this case, I would love to ask if I could submit some questions. Can I submit some questions like, have you ever catfished someone named Rachel? Have you ever pretended to be someone named Hope? Or Marcus? Or somebody else? Anyway. I will say, though, on a personal level, I have some concerns because I have had several clients that have passed the polygraphs in their day. But I've also had the most craziest narcissistic psychopaths also fail. And they've told me a multitude of reasons, which I find really interesting. One of them told me that the cartel had hacked into her brain and had planted seeds of doubt, and that's why she could not give a straight answer. Anyway, the guy that was actually administering it is ex-FBI, and he brought his son to bring your kid to work day, and he was like, this is the best experience he could have ever gotten. I'm like, I know. And she's like a very big criminal, so anyway, it's not fail-proof, it's not foolproof, it's not guaranteed, but it's interesting. It'll be interesting. So we'll just follow that story as we learn more, everybody. Thanks for tuning into that moment. But yeah, it says that she agrees to be interviewed before and after. There's actually 2 U.S. attorneys assigned to this defendant's case. They are all taking their own responsibilities. There's one AUSA that is assigned to the criminal side, and then there's somebody assigned to the forfeiture, because they take forfeitures very, 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 very seriously. I will say there was somebody that I saw a video of once on TikTok. They were talking about this defendant and how she had so much money in her possession, and she never, ever, ever purchased like a residence or a vehicle that she kept. And the reason is because that shit would be gone. I'm not suggesting that anyone should do this, but if I was going to be a criminal, I would say spend that money, honey, because if you don't, anything that you spent it on is getting snatched. They're taking that shit into custody, and they're going to end up selling it if you cannot give them the assets that they need. So, just a thought. Just a thought if you ever plan on going to federal prison, which, again, I would not recommend. It is not like Martha Stewart says. It's not fun. It is not club fed. But I would go there if I needed to lose some weight, and I wanted to just be very isolated from the world. So, but I'm not. I'm not going. But I do know some others that are. I lied. There's one other sentence I want to say. The defendant acknowledges that the defendant is entering into this agreement and is pleading guilty freely and voluntarily without reliance upon any discussions between the attorney for the government and the defendant and defendant's attorney, and without promise of benefit of any kind. What that means is you cannot come back later on and say, but my lawyer said in a text message that I am not going to jail. I will say that CC already said this on hers, but it's accurate, and she and I have talked about it. Jail and prison are very different. Jail is the county jail. It's where you sit and you wait unless you've got a sentence under 365. If you've got a sentence for 364, you go to the county jail and you get nasty food and it smells like shit. If you get more than a year, you go to Club Fed, Federal Bureau of Prisons, BOP. If you stay in Florida, you're going to Coleman, baby. They got a lot of levels. Been to them all. That's actually where my one client was murdered, so food still sucks, but not as smelly. So, anyway. Not jail, maybe. Actually, you will still go to the jail, though. You'll go to the jail once you get sentenced. You can't go directly to prison. You have to actually go to the jail first, and the United States Marshals will transport you. I will say, though, in my experience, I have had so many clients come to me afterwards. The number one thing that I tell my clients is I will never lie to you, because most clients come to me and they have been lied to some degree. Maybe not an outright lie, but a bluff, a fluff. They'll fluff it up. Like, for example, like if it says 24 to 36 months, their lawyer will say, we got you. We're going to go to a downward departure. We have proof of mitigation. We've got family support. You've accepted responsibility. The victim's coming to court and they're going to get on their hands and knees and beg. And what's going to end up happening is none of that. And you're going to get prison. There's only like 2 people that I ever have known that got exactly what was discussed. And I say that, and those 2 people were really below the guidelines. A lot of other times I've had clients that took pleas and then they thought that they were going to get agreements based off of their cooperation. And then their cooperation wasn't shit. And they literally got so screwed and got more time because the government was like, you lied. You lied in your proffer. You get nothing now and you get more time. It's a very, very dangerous game. People don't understand that playing with the government is not a friend to play with. They're not your friend. They are not someone to be toyed with. They're not somebody to con. They see right through your bullshit. Hence why they file these charges in the first place. So this is the final section, guys. And we're going to go paragraph by paragraph. And I'm going to make it really quick because I'm tired. We're tired, okay? I might not go paragraph by paragraph. I'll make stops where I think it's appropriate, okay? So between October 2021 and December of 2025, the defendant, I'm not going to say her name, engaged in a scheme to defraud victims of funds by making false and fraudulent representations that she suffered from a cancer diagnosis. In reality, the defendant has never received a diagnosis for cancer and has never been treated for such a diagnosis at Hospital 1 or Hospital 2. And I am not making fun of this person. I'm merely having some emotion because I find it incredibly disgusting as someone who has lost family members to cancer. My mom's on a trip right now with one of our best friends who I did a actual GoFundMe for last year, right before I stopped being friends with this person. And people questioned if I had made that GoFundMe for this person. And I just found out that she's going to die. Like people who talk about this, it's fucking disgusting. Truly gross. The defendant met the first victim, J.H., podcast, if you guys know, and connected after both went through divorces. The defendant told him repeatedly that she was terminally ill and needed funds for treatment, which he provided. The defendant also advised J.H. that she would pay him back. The money provided was specifically for medical treatment, but she used it for other means as she was never sick. I'm going to skip through this portion of this because it is very thoroughly covered through Jason's segment on the podcast. And for everyone that talked shit about him or was rude to him about his experience, you can fuck all the way off. Because if you've never gone through this, then I don't want to hear it. And if you've gone through it, then you should be more supportive than anyone else because it happens to anyone. I mean, if you guys could meet RP, you would understand the level of intelligent. It's wild. All I will say though is for Jason, his amount of money, I think it's around $500,000, the forfeiture portion of this. So yeah, so we're not going to go through the rest of those because I just think that it's just not. Oh, it says, the defendant's financial records revealed that at no time did she use the funds for cancer treatment. The total loss amount for Jason was at least $470,090. Anyway, if you guys forgot, this is the individual who literally lost everything. He was selling his son's belongings to help with this person who he was determined to save, which make fun of him if you want, but I think that's actually just a really genuine human being. And I probably would get stuck in the same set of situations, so no big deal. Call us empaths, call us whatever you want, but at least we're not going to jail. So, the next part, in May of 2023, when if you guys remember, I met the defendant in May of 2023. Here we go. I'm not going to show these though. This makes me really uncomfortable if I'm being honest, so I'm just going to talk very straightforward because I can't think about this too much because it's obviously very still present for me right now. So in May of 2023, the defendant met victim RP in Tampa. We all know it at Fort Beachy. Shortly after meeting RP, the defendant advised him that she had stage 4 lymphoma cancer and needed money for treatment. The defendant advised the victim that she was going to inherit millions from her deceased father, who is not deceased. Rick is very alive. But she could not access any funds due to a divorce, a custody battle, and bad credit due to medical issues. RP believed the defendant would pay him back from her inheritance. The defendant specifically referenced needing funds to treat at, quote, Hospital 1, and then they gave a couple of examples about the money. She alleged that she needed surgery, but that the hospital would not do it without cash, $21,000 in total. In June of 2023, the defendant advised RP that she was being released from a clinical trial as she did not have the funds to pay. Wow. On or about June the 5th, RP wired $10,000 from institution number 2 with an account ending in la 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 to an account at institution number 3 belonging to the defendant's mother. My bad, I forgot. So belonging to the defendant's mother, and if you guys forgot, the defendant's mother is how I met her. I would love to know where Trish is, actually. Or where are you? Because apparently you have assets, or that's what your daughter has told the government, which I don't believe for a single second, because that's insane. RP included a memo line in the wire that read this, quote, medical expenses. Later, the defendant messaged RP purported proof that the wired funds were used for medical bills. What that basically means is she made a fraudulent document that basically reflected a medical bill. Anyway, in reality, the defendant used RP's funds for hotels, beauty supply stores, nail spa treatments, and clothing. To pay the defendant, RP withdrew funds from his 401k account. The total loss amount was at least $700,550. Which included expenditures of, I'm just going to say $425,000 in credit card payments, debit card payments, food purchases, internet payments, clothing, beauty and spa treatments, pet care, video game purchases, her child, travel, and online peer-to-peer transfers and wire transfers by the defendant. The remaining amount was in cash payments. None of the money sent was used for medical cancer treatment. This created a financial hardship for RP. After withdrawing funds from his 401k, he returned to work full-time in order to afford medical insurance and pay his bills. I can tell you this much. RP is now 78 years old, and he was probably supposed to retire this year, and he won't be retiring for a while. So that's really unfortunate, and he's a really good person. So anyway, in August of 2023, AR provided her with money on 12 occasions totaling over $3,000. AR also received text messages from an individual he believed to be the defendant's father, who claimed that she was dying and needed money quickly. The investigation revealed this was not the case. The defendant's father, he is not dead by the other means, but is alive, and it was not actually him, and it was actually the defendant. She impersonated someone. Oh, this makes so much sense, actually. Holy shit. And I'm going to get into this in a little bit. I'm going to talk about the catfish at the end of this, and this is really important. Actually, I'm going to put a little bit of a little check and highlight, you know? This might have to be a 4-part thing, because I think the next part will be like what's happened since the filing of the charges, and then the 4th part will be how I think that the catfish kind of comes into all of this. And this is very important, okay? Moving on, the defendant therefore engaged in a scheme to defraud others into funding an extravagant lifestyle through misrepresentations of illness, and did so using lies and pressure-filled tactics such as needing money urgently, contacting the victims through various numbers, and impersonating others to achieve her goal. I can't imagine impersonating someone. That's wild. Anyway, that's it. So what's really interesting about that last part, and I just want to mention this in passing because I'm not going to get into the depths of this, but when I was obviously talking to the catfish, I was very deep in the situation. What's so weird to me though is that remember on the podcast that Cece and Sherilyn did, there was a discussion about the website that they had claimed that Elizabeth had made. I don't necessarily still believe that. I'm going to be very honest. I just don't, because it's still up. Why would you not take it down? But I did look at it today because I was trying to find out the specific dates of something because I have to prove something. And when I was looking at this, I realized something. She and I stopped being friends September 29th of that year. It's the same day that I picked up my sister's dogs at her house. What's so crazy though is I did not speak to her again. I talked to her one other time on October the 5th. She's like, why did you delete me on everything? Why did you block me? Why did you ghost me? And I told her, and I have the text. I said, I'm sorry. There's a lot going on with like your case, my stuff, blah, 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 my job. I had to focus on my job, and I unfriended her everywhere. What's interesting though is that was not true. And I've never really talked about this online, and I'm not going to go into all the details right now. But all I will say is this much. The next day was when I learned that I would not be working at my firm anymore. And there is very much a connection between those two things, that person and my job. And it's just really interesting to me because what happened after that is I don't know what date that there was a surgery that was paid for and obtained for some some yitties. But that's not my problem. That's not my reality, not my thing to tell. But I'll never forget, my sister went over there to visit her. And as she was arriving, she was going to say hi and make sure she was doing well. She saw AR leaving. And when he was leaving, he walked up to Jordan and he said, "Oh my God, I just gave her those photos you guys asked for." If it was me, I would have been like, "What the fuck are you talking about?" Jordan's like, "Oh my God, yeah, what photos were those again?" I think Rachel's one that asked her to get those. The photos from the Heron parking garage of the G-Wagon of the catfish, the guy's name. Why is this so interesting, you're asking me? Because why would she have needed to get those photos? Why was she looking into this when we weren't friends anymore at this point in time? And what's even weirder is, why do I have pictures from a week later from a Snapchat sent to me of a G-Wagon in the fucking Heron garage by the catfish? Circumstantial, I know. Circumstantial, but if I was on a jury, I'd be like, "Mari, we have the results are in. You are the father. You are the father. You are the father." That is wild. And I keep like finding these little things that put them all together. That's why I got the boards, guys. That's why I got the boards. Because I can't like really fathom, and I don't have a wall big enough to do like the beautiful mind shit on the wall with all the lines and stuff. Sherilyn and I always joked about doing that with the catfish. And the new name associated with the phone number that I spoke to, the last name is the same last name as RP. Standing in the corner. I still don't know, and I never will know, but we're gonna get through it for the rest of the weekend. I'm gonna reveal that later on. So anyway, so yeah, my personal opinion is that based off of this agreement, if every single term was satisfied, I still think that she would get prison. I think that she would get 2 years. There's a couple of things that I've learned since though. Number one, if you are a victim to this woman, this person, and you are not named in this information, you will not be allowed to speak at her sentencing unless you are identified as a victim. So, victims normally would write a letter to the judge explaining who they are. You will not be included, but at least your name and your amount of money will be noted. What has also come to fruition is, because of all the harassment and all the other stuff that's gone on, obviously I have discussed my fear. And it's not my fear for my life. It's with a fear for what could happen and the unknown and just the constant state of chaos in my brain. I literally feel like I'm having a heart attack, like right now, all the time. And so when I reached out to my friend and her dad, they realized that probably one of the only ways that this could happen is if I was actually considered a victim that is associated with these two crimes. So you cannot be a victim of this case unless you are associated with these two wire fraud counts. But the good news is I am. The good news is that I am the person that helped get this, if you will. So that's not all you have to prove, though. You have to also prove that you have had a significant damage as a victim. But what's interesting about this is if there is an allegation that is established of impersonation through a victim, what I have learned today is that that automatically adds on 2 years on your sentence, automatically mandatory. No ifs, ands, buts, no coconuts, no nothing like that. It is a mandatory minimum addition that has to be proven, okay? And it's only if this is accepted, which it might not be, and it might be. If I was them, I would just say, listen, I don't want restitution. I don't need my life paid for. I want the victims to get their money back. I have spent so much money. I have lost so much money because of my career, my reputation. I probably will not be a lawyer one day because of this, because of the way that I feel, because of this entire situation and how it's treated me and everyone else involved. But I don't want that money. I just want her to leave me alone. And I was like, why would you not just agree to that? Instead of risking all this. So now I have to go to court probably, and RP is going to come to court, and we're going to establish that somebody impersonated me. Anyway, come back for part 3. It'll probably be the end of the weekend because I'm not doing shit this weekend except for going through my boards, and I'm going to have them on display for the next video. The next video, we're going to talk about everything that's happened between her getting charged and what I believe is, I talked about it in a video that I posted on here and on TikTok. I think it's all this massive conspiracy to set me up. I just do. I don't know why. Probably because I brought this reigning terror on her, but I did not create the terror, but whatever. I get emotional sometimes because I wish I could go back, but I also don't wish I could go back. Because I know that night when I threw up in the bathtub, and every time I see RP, every time I talk to Jason, every time I talk to any of them, my heart like actually melts. So I will endure the pain and suffering for all if this is all ends well and the defendant ends up in a jumpsuit. Jesus, take the wheel. And not a pretty one, not one that you wear to a white party or a gala that you tell your friends you paid for with your own money and really it was somebody else's, because that's fucking gross. Anyway, see you guys next time. Bye!